Lawyers Infohub, and hope you're doing well in whatever you're doing. If you're a returning subscriber, I appreciate you. Thank you for always stopping by to check what is new on the channel. And if you're a new person on this channel, please hit the subscribe button, hit the notification bell, so whenever I drop a new video, you will be notified. So we started a series discussing the new Court of Appeal rules of 2021. We did a part 1, so this is the concluding part of that series. We looked at the Court of Appeal rules of 2021 and we looked at the new things that were introduced, the new innovations in the rule. And we did mention in the previous video that these new rules incorporated electronic issues like virtual hearing, in the wake of the pandemic and what has befallen the whole world. I'm going to link the first part of this video to this video so that if you've not watched it, it will be beautiful if you watch it and watch this one so you have a proper understanding of what we have been discussing. So in continuation, we looked at just like what we discussed in the previous video. So we mentioned several innovations that have been introduced. So in continuation, Order 15 Rule 4 talked about substitution of name. So Order 15 Rule 4, I'm going to read it out to you, is a new introduction into the new rules we have, a new innovation. It says where the name of a party to an appeal changes during the pendency of the appeal, the party or the appellant shall apply to the court in the manner prescribed in the rule for an order of substitution. And sub 3 now says where an appeal has been set down for hearing and the court is or becomes aware that the necessary party in the appeal is dead, the appeal shall be struck off the hearing list unless an application for substitution is made. So Order 15 deals with death of a party, change of name of a party to appeal, which calls for substitution. So you have to read Order 15. It had some new innovation in it, that was not there in the old rules. Now, in the case of default fee, in this new rule, the default fee was now, has been increased from 100 naira per day of default to 200 naira. So you can check it up under Part A of the third schedule of the rules. So before now, under the old rules, once you're in default, they calculate each day at 100 naira, but now each day of default will now be calculated at 200 naira. That means you don't anything that will make you to go on default or to file what you're supposed to file within time. You have to avoid it because you're going to pay double of what you used to pay. So I think this provision is to awaken lawyers, to awaken litigants and all counsel to begin to be diligent in their duties so that you will not now say it's the court that is now holding or that is wasting time. So if parties or the counsel can do all they can do within time, I think once the briefs are in, whatever you want to file is in, then the appeal can be heard. So increase in default fee is a new innovation in the new rules. So we're under the new rules now. There was a practice direction on cost. The practice direction on cost 2021. That practice direction reviewed various cost benchmark which the court can give as against what was obtainable under the practice direction of 2007. So under that practice direction, there's benchmark of the least amount the court can award for different things that can happen in the court. So it's a new thing as against what was obtainable under the old practice direction on cost. Now, another thing that was added in the new rules is about withdrawal of appeals by consent. Now, we're going to look at that one at Order 11. So Order 11 deals with withdrawal of appeal. So we're going to look at Sub 2 and Sub 3. So under Sub 2 says if all parties to the appeal consent, about withdrawal of appeal by consent. If all parties to the appeal consent to the withdrawal of the appeal without an order of the court, the appellant may file in the registry the document or document signifying such consent. If the appellant and the respondent or the parties in the appeal comes together and say, okay, let's withdraw this appeal, maybe we have settled or we're no more in, at loggerheads, or we've resolved that issue, whatever it is, and both parties come to say, okay, we have agreed at the meeting held so, or just like you're filing terms of settlement, you have agreed. So the counsel here can, say you can file in the registry the document showing the consent of all the parties and signed by the parties. In this way, it can be like terms of settlement or any document to show that parties have assigned to say, we are no more going to, take on this appeal. Let us withdraw this appeal. Signed by the parties and or you have to look at that. Either it's signed by the parties and their counsel or their counsel. And the appeal shall upon be deemed to have been withdrawn. In such event, any sum deposited against cost shall be paid to the appellant. Any sum deposited against cost shall be paid out to the appellant. So this order is very key, that if parties intend to withdraw by consent, the parties must sign a document showing that we have our consent have been obtained to withdraw this appeal. So counsel will now file that document, either signed by the parties and or with their legal representative, and file it in the court registry. The rule is saying that thereupon the appeal is deemed to be withdrawn. This is very important. Now, under 19 Rule 10 sub 3, when you look at Order 19 Rule 10, look at the effect of non-filing of respondent brief. This innovation is really, really, really nice. It's all aimed as quick dispensation of cases, quick dispensation of justice. Rather than one person frustrating the whole process, the court can go ahead to hear this matter without, that person, for the fact that that person has proof that person has been served. So Order 19 is the order talking about brief of argument. Now, under Order 19 Rule 10, let me get it, so I'm going to read it out for you. Order 19 Rule 10 sub 3 says, where a respondent who has been duly served with the appellant brief of argument fails to file his brief within time, as stipulated in the order, or within the time as extended by the court shall, upon being satisfied that the respondent was duly served with the hearing notice, hear the appeal without the necessity of an application by the appellant to hear the appeal or to hear the appeal on the appellant brief alone. This is very important. Before under the old rules, where the appellant has filed his brief and the respondent refuses or has failed to file, the appellant can bring a motion to say, hey, please hear the appeal on my appellant brief alone. So the court is saying with this new rules that it need not file an application, separate motion to say, please hear my appeal on the basis of the appellant brief alone. The court is saying once that is proved that the respondent has been served and he has failed to file his brief, the court can go ahead to hear the appeal, without having recourse to the respondent. This is very, 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 very key. But before that, I have to file an application, say to hear it on the basis of but this rule is trying to dispense all those bottlenecks, whatever that will stop the hearing of an appeal. And, sometimes people say, go to appeal, spend 10 years. You need not spend 10 years. These days, you can go and appeal in less than 1 year and 6 months, you can get judgment. Yeah, I've seen it happen. Lesser time, these things can be, because it's an appellate court. It's not going to hear evidence. You just file in your paper. So I don't know why a lot of people drag their feet. As much as they say writing of a brief is difficult and all of that. But if both parties can file in that brief, so I think you can get a date. And I've seen appeals that are 1 year, 2 months, 1 year, 3 months, 1 year, 4 months, and judgment was given. And you begin to wonder, why do we not have ones that spend 10 years, 15 years, 12 years, 8 years, 7 years, 6 years? So this provision of Order 19 Rule 10 sub 3 is key and very important. It will help in the drive for quick dispensation of cases. Now we look at Order 19 Rule 2, Rule 12. Order 19 Rule 12. Yeah, Order 19 Rule 12. Where it talks about that time stops running. Let me get it. Order 19 Rule 12. It talks about stay of computation of time and exemption from payment of default fees. That rule is saying that whenever something occurs that disrupts the business of the court from running, those days shall be exempted for payment of default fees. So once there's any occurrence, in the time during the pandemic, the court had to stop. There have been instances that has made the court sitting to stop, the business of the court to stop. So such things, when they happen, the rules is saying there won't be any issue. There will be an exemption on default fees. So we've been able to run it through. By the time you buy your rules and read, you're going to see other things and compare it with what is in the old rules and what is now in the new rules. So in summary, we've talked about a whole lot of innovations, in the previous video and this video. So putting them together, you will see that there was really serious work done on the new rules, and I give it up to the draftsmen. They did a whole lot of things, and we factored in the times we're in. We factored in the fact that the world has changed and the technology is now the drive. Technology is now everything. It's now the wings on which a lot of activities are flying. So it was incorporated into our judicial system, to the appellate system, and it's been amazing. So that you can even sit at the comfort of your home and do a whole lot of things, filing your process, serve the other parties, take your hearing, yes, without even visiting the court. I must say, of all the things that was introduced, I'm so very happy with the virtual hearing thing. It's amazing. If you can really maintain it and it is functional in all judicial divisions, I must tell you that the stress a lot of lawyers go through will reduce. And as much as we want to do our best, we must also take care of our health. So friends, I hope you've learned something. Go get your rules, the Court of Appeal rules of 2021. If you've not bought it, if you have bought it, sit down, take out time and read it and understand. A lot of things have changed. Things are unlike before now. Like you file a motion, you don't need to file a written address unless ordered by the court. But now, filing of written address is now compulsory. These are a few other things that have added issue of the fact that the appellant will have to deposit a sum no less than 50,000 when he's filing an appeal. So these are new innovation. The default fee has increased from 100 naira to 200. Issue of substitution, issue of computation of time, electronic filing. So this substitution of name. So these are many more, have been introduced. So go read your rules and check the new things so that you will not lag behind and go to court and embarrass yourself. We have wonderful contents on this channel. Please, if you're yet to go through the videos, go through them, drop in your comments, engage me, engage others, so that you learn. Drop your comments so we can hear what you have in your mind and respond if need be. So friends, if you've not subscribed to this channel, hit that subscribe button. I want to thank you, amazing. You've been one of those driving me to continue making videos, contributing my own quota to the growth of our legal profession and the legal education. So do take care of yourself and stay safe. I know that you can always be the best. You can always be the best. To take care.